Hello students, welcome you all to Sunya IAS. Welcome back to Top 50 Rapid Current Affairs. The revision must be on because the exam is very much nearing for the Prelims 2024. The schedule, how we are revising and how we have curated this Top 50 Rapid Current Affairs is so that you get hold on to the most important news items of each month from the month of May. 1 to 5th will be covering one particular month. It is divided in this section wise. 11 to 15 एक अगला महीना कवर करेंगे. 21 to 25 नेक्स्ट मंथ विल बी कवर्ड. तो इससे क्या फायदा होगा कि आप एक छोटे से लिमिटेड स्पैन ऑफ टाइम में बहुत सारे टॉपिक्स रिवाइज कर लोगे. वी आर नॉट गोइंग इन डिटेल्स ऑफ दीज टॉपिक्स. वो करंट अफेयर्स क्रैश कोर्स में वी आर गोइंग देयर, बट हियर यू कैन गेट होल्ड टू द मोस्ट इंपॉर्टेंट टॉपिक्स ओवर हियर एंड द रिलेटेड इंफॉर्मेशन. How we have started from the month of May here. May, June, July, August, September, October done already. November month we are continuing. 2nd March, 1st March, 2nd March. 2nd March we are going to do polity, governance and international relations. Economic development we have already covered. 3rd March, environment and ecology. 4th March, science and technology. 5th March, reports, indices, defense, government schemes and miscellaneous topics. This is how you should also be preparing your examination. These are some segments of it. If we go in detail more about the things, even for the miscellaneous, the course has been curated in the form of current affairs crash course for UPSC CSE Prelims 2024, where emphasis has been given on the PYQs, previous year questions, and the changing pattern of the UPSC. Pattern change हो रहा है. It's not just about mugging up knowledge or facts. You have to understand the context of the news, because UPSC कभी कभी पेरिफेरल एरियाज में से जाकर के क्वेश्चन पूछ रहे हैं उस टॉपिक के. आपको इंटरलिंकेजेस समझने पड़ेंगे. How the question can be framed for any news items, related to the polity. For example, today we are going to discuss about the Article 200, the position of the governor, the discretionary powers of the governor. अब वहां से कैसे क्वेश्चंस आएंगे? कॉन्स्टिट्यूशनल डिस्क्रिशन क्या है, सिचुएशनल डिस्क्रिशन क्या है गवर्नर का, बिकॉज सुप्रीम कोर्ट हैज गिवन सर्टेन रूलिंग्स इन दैट केस. तो ये करंट अफेयर्स और स्टैटिक का लिंकेज, अनलेस एंड अंटिल यू आर क्लियर विद इट, you won't get a hands on the paper, a confident hands on the paper. Okay, you can join this program online from the Sunya IAS website, and soon the program is going to be launched offline in the Delhi. You can ask the desk in the query on the following numbers. So let's start Article 200. Now understand, students, governor, whenever a bill is presented to the governor after it is being passed by the legislative assembly, okay, what the governor can do? Governor can give his or her assent to the bill. The bill is deemed to be passed. He or she can withhold the bill. Then he can, ask for president's advice, and then he can return the bill with certain, amendments into it. And if the bill is again passed by the legislature, then what will happen? A legislative assembly, then the governor must give his or her assent to the bill. So governor can also suggest any new amendments to the bill. That is for sure true. Governor can give his or her assent. Problem arises when governor, just withholds the bill. For a very long period of time. Now understand, students, what is the consequence of it? This matter was referred by different state governments to the Supreme Court, and Supreme Court then referred it, and here Supreme Court referred it to a bench, okay, including the Chief Justice of India itself. Now here the Supreme Court said that the governor should not be oblivious of the fact that they are not elected by the people. Therefore, the elected representatives of the state, they are deemed to make certain laws. The bill must be passed. If the legislature has passed the bill, then it should become a law. It should be executed. Getting the point? Here the governor is not an elected representative. Rather, one must understand governor has to complete the dual role, one being the representative of the central government, other being the constitutional head of that particular state. Okay, सो सर्टेन डिस्क्रिशनरी पावर्स आर देयर. यहां से ही क्वेश्चन बनेगा डिस्क्रिशनरी पावर पे एग्जाम में. Constitutional discretion and situational discretion. Constitutional discretion when they have to reserve the bill for the consideration of the president. This is a constitutional discretion. When he has to recommend for president's rule in the state, it's also constitutional discretion. Tell me the article. Which article has given this power to him? In the comment box. I want to see that how much you can remember the polity. Static portion of the polity. When given additional charge as administrator of the union territory. UT का भी जब हम charge देते हैं as an administrator, वो भी constitutional discretion है. More constitutional discretions are there. Situational for appointing the chief minister after no party gets clear majority or when the incumbent dies in the office. उस समय the governor has a situational discretion where he can ask somebody to become the chief minister and prove his or her majority on the floor of the house. When he dismisses council of ministers on an inability to prove confidence in the legislative assembly. When dissolves the assembly when it loses its majority. This is also situational because it can happen anytime. Okay, so recently what has happened that Supreme Court has expressed acute displeasure at the governors holding back key bills, essentially in non-BJP ruled states such as Punjab. This is also impacting this Article 200. What basically Supreme Court said that the governor must obey the rules mentioned in the Article 200. It is not their discretionary power that they will keep the bill, under the withhold, okay, or for the reconsideration of the president for a very long time. Tamil Nadu, Kerala and Telangana until state governments approach the top court for judicial intervention. Clogging of the judiciary. State in general, I am talking not here about union and state government, but state is the largest litigant in the Supreme Court itself. तो यहाँ पे उन्होंने कहा है कि गवर्नर को भूल नहीं जाना है कि भैया आप लॉ मेकर नहीं हो, आप इलेक्टेड रिप्रेजेंटेटिव नहीं हो, इसलिए यू आर ऑल्सो बाउंड बाय द आर्टिकल 200. आप इसके रूल्स को फॉलो कीजिए एंड यू मस्ट अबाइड बाय इट. यू शुड हैव अ रीजन कि आपने ये बिल क्यों नहीं अभी तक पास किया है. एक लिमिटेड टाइम फ्रेम में आप इसको सोचिए और इसको क्या कहते हैं पास कीजिए और टेक एक्शन ऑन इट. एक और केस इसके रेफरेंस में हम देख सकते हैं, नबम रेबिया केस. नबम रेबिया केस इज रिलेटेड टू अ डिफरेंट थिंग. The Constitution Bench of the Supreme Court has held that governor is bound to convene a meeting of the assembly for a floor test on the recommendations of the cabinet. ठीक है, ये अभी भी महाराष्ट्र में शिंदे faction, ठाकरे faction was there and Nabam Rebia case was into the news. Therefore, here also governor is employed. Therefore, just I brought this point also here. Nabam Rebia and Article 200. I hope you get it. So let's understand a little bit of static here also. A lot of PYQs are there. Because of short span of time, I am not discussing PYQs here. Eligibility criteria related to the governor, you should revise. Dual capacity constitutional head and representatives of the union government. What is the appointment and tenure procedure? Appointed by the president, Article 153, one person can be appointed as governor for 2 or more states. 7th Constitutional Amendment Act 1956. Holds office at the pleasure of the president, maximum 5 years. Ending tenure before 5 years. What are the provisions? Simple thing it is. Powers. Okay. Part 6, Article 161, pardoning power. Powers to appoint the chief minister and other ministers. Special address by the governor. Okay. So these are the powers certain. Responsibilities, appointments and ex officio chairman of the state universities. I hope from the static you will be revising definitely the governor portion. Let's come to the next topic, that is Insolvency and Bankruptcy Code. IBC code was introduced in 2016. Okay. To speed up the resolution of stressed assets into the country. Stressed assets, I'm not here talking about the NPA. Non-performing assets only. Stressed assets is a word that certain companies or corporations are there which has taken certain credit from the investors. Creditors, the word creditors are there, debtors are there. So what happens if you are not able to pay back your money to the investor? Then what we can do? There are different levels of the investors, how the money will be released. Therefore, we had Insolvency and Bankruptcy Code. It was a necessity because This will help in ease of doing business in India. So covers all individuals, companies, limited liability partnerships and partnerships formed to decide whether to revive the company. क्या आपको कंपनी रिवाइव करनी है, एक इंसॉल्वेंसी रेजोल्यूशन लेना है, और लिक्विडेट इट, और यू वांट टू सेल इट इवन, सो दैट आप अपने इन्वेस्टर्स को मनी दे दो. You can understand, recently, you would have seen the Trumps, if I'm right. Trumps is the brand name of an apparel. Basically, how it has liquidated itself it has sold itself, liquidated itself basically. But it was also not able to pay back the money to its investors. देखो यहाँ पे जो है, one thing is called as debt recovery tribunals, DRTs, or National Company Appellate Authority. Okay. National Company Law Appellate Authority, NCLAT. What happens? It looks into the matters related to the companies and limited liability partnerships. Whereas DRTs looks into the matters related to the individuals. It looks into the matters related to individuals, as well as it looks into the matters of certain partnerships also. So basically, what is the purpose of this? It works as a regulatory oversight. Insolvency professional agencies develop professional standards, code of ethics, and first level regulator for insolvency professionals. Enables provisions to deal with the cross border insolvency as well. Okay, see how it has been developed. NCLT. Speed up the resolution of stressed assets applicable to individuals, partnerships, LLPs, corporates. Authority to decide insolvency application within 80 days. 90 days extension allowed. Fast track the process for the insolvency and adjudicating authority and NCLT, DRT for individuals and partnerships. Anticipatory bail. These days, UPSC is asking certain questions related to the words of law. जैसे एडवोकेट लॉयर में उन्होंने डिफरेंस पूछा, फरलो और बेल, परोल में अंतर पूछा उन्होंने. व्हाट इज बेल? अभी एंटिसिपेटरी बेल में बेसिकली प्रिया इंदौरिया वर्सेस स्टेट ऑफ कर्नाटका एंड अदर्स 2023, सुप्रीम कोर्ट हैज टॉक्ड अबाउट ट्रांजिट एंटिसिपेटरी बेल. Transit anticipatory bail. Okay, now here again understand students, transit and anticipatory bail, ये वर्ड ही बहुत नया है. ठीक है, इसको later on this word came to the force basically in 1998 itself. Okay, we are talking about anticipatory bail. Bail before the arrest. एक होता है bail are different types of bails are here. Okay, bail types: regular bail, anticipatory bail, interim bail, default bail, and medical bail. Different types of bails are there. You should be understanding, familiar with these words itself. Okay, so this transit anticipatory bail is important because what happens, for example, if a person is falsely going to be accused in case of, for example, in case of harassment at workplace, or if the person is going to be accused because of personal animosity, okay, against cognizable non-bailable offenses. Cognizable non-bailable offenses. In that case, from the sessions court or the high court, a person can avail ट्रांजिट एंटिसिपेटरी बेल, कि हम अरेस्ट होने के पहले ही अपना एंटिसिपेटरी बेल ले लेंगे बिकॉज यू आर इंपॉर्टेंट for the work and you had good conduct. You can have the clauses that because of certain reasons other person is going to falsely frame me for such charges. Okay, bail is basically a judicial release of an accused person from the custody on the condition that the accused person will appear in the court at a later date. ठीक है, हर केस में ऐसा होता है कि हम बाद में श्योर करते हैं कि द पर्सन विल कम. यहाँ पे पर्टिकुलरली इफ आई टॉक अबाउट एंटिसिपेटरी बेल, यू विल फाइंड the section 438 of CRPC. Okay, section 438 of the CRPC. Here what happened that previously, for example, if I talk about sessions court or high courts, they have jurisdictions, they have territorial jurisdictions. Supreme Court said that without, for example, if FIR has been lodged against the accused, even outside the jurisdiction of the High Court or Sessions Court, then also they can issue interim bail. क्योंकि इतना important क्यों हो रहा है interim bail, transit interim, anticipatory bail, not interim bail, anticipatory bail. The reason is that because Article 21, right to life and liberty, Supreme Court's responsibility is to protect that. अगर because of any reason that article is being hampered, तो फिर हमको ये कोई टेरिटोरियल जुरिस्डिक्शन वाला क्लॉज मैंडेटरली नहीं लेकर के आना है. ठीक है. सो डिफरेंट टाइप्स ऑफ बेल्स, इंटरिम बेल, टेम्पररी form of bail granted during the pendency of an application for anticipatory or regular bail. Just for that, interim bail is there. Default bail, basically, for example, if someone has been arrested by the police and they were presented to the magistrate 15 days like that, more remand can be increased. But even after 60 days or 90 days, no charge sheet or complaint can be filed against the accused, then the default bail goes there. Medical bail on the medical conditions would be issued. Certain background has been there, but the question would be asked from the current itself. Fast track special courts. It's a central sponsored scheme, students, to resolve the matters related to the sexual harassment of the women at the workplace, POCSO Act. These rape victims, in these cases, what happens? Justice delayed means justice denied. So government had already launched back in August 2019 this fast track special courts, and recently what has happened that the timeline for this particular initiative or scheme has been increased up to March 2026. Okay? Fast track special courts, stringent punishment to the culprits, immediate relief to the victims. Objective was to give immediate relief to the victims. Fast track special courts. It is implemented by which ministry? It is implemented by which ministry? Which ministry would be implementing it? I get to you that some students would be thinking that, sir, because this special courts are particularly for the women, okay, rape survivors, the victims, the POCSO Act, therefore WCD, Ministry of Women and Child Development. No, it is done by the Ministry of Law, Department of Justice. Okay. Electoral bond scheme. Now we all know that electoral bond scheme. Let's understand a little bit background about it. It was introduced in 2017-18, available for the purchase for a period of 10 days each in January, April, July and October, and उसको बढ़ाते ही जा रहे थे. Timeline exemptions, the government was increasing electoral bonds के लिए. Interest free bearer bonds or money instruments, basically just like a promissory note, and it was applicable only with the SBI, State Bank of India. अब देखो इस पे क्वेश्चन तो आएगा नहीं, because it has been nullified or declared unconstitutional by the Supreme Court right now. So it was only with the SBI Bank, interest free bearer bonds or money instruments. What was the problem? You need to understand. थोड़ा timeline भी देख लेते, then we'll come to the point. Electoral bond scheme introduced in 2017, then 2018 central government notifies electoral bond scheme. फिर electoral bond scheme amended to increase the sale days from 70 to 85 in each year. Sales बढ़ा दी गई उसकी, so that the corporates can contribute more money for the registered electoral parties. Okay, basically it was devised as an mechanism for electoral funding to curb the black money and increase the digital India. सुप्रीम कोर्ट में केस आया भाई. फिर केस कह रहा है कि ये इलेक्टोरल फंडिंग में आप इतना ज्यादा पैसा जा रहा है जिसके बारे में लोगों को कोई इंफॉर्मेशन नहीं है. फ्रॉम वेयर द मनी इज गोइंग, हु इज डोनेटिंग दिस मनी, व्हाई यू आर एग्जेम्प्टिंग दीज पीपल फ्रॉम दिस इंफॉर्मेशन. So lot of things are happening. Right to information, right to privacy, right against equality towards political funding also. Okay, Supreme Court bench headed by the Chief Justice of India, D.Y. Chandrachud, refers pleas against scheme of 5 judge bench. कॉन्स्टिट्यूशनल बेंच, याद रखना कॉन्स्टिट्यूशनल बेंच की जजमेंट्स बहुत इंपॉर्टेंट होती हैं. 5 judge constitutional bench added by D.Y. Chandrachud starts the hearing and reserves the verdict, and it delivers unanimous judgment annulling the scheme, calling out unconstitutional. What were the problems? देखो question, this is the current affairs, question will come from the static portion as well. Unanimous verdict upheld every challenge to every aspect in the electoral bonds case, declaring the scheme unconstitutional. It is against Article 19 Clause 1A because it is a violation of right to information. We are not declaring this information in the open public domain. This is an infringement upon it. Okay, you understand? Okay, here we also discuss proportionality test of right to privacy. Okay, right to privacy has evolved a lot. K.S. Puttaswamy case, 3 stages K.S. Puttaswamy case. It has given 3 criterias for the right to privacy. One of them is proportionality test. Even if अगर हमको थोड़ी privacy रखनी है, for example, who are the contributors, who are the donors, बट उसकी वजह से क्या इतना बड़ा इम्पैक्ट क्रिएट हो रहा है, सच में ब्लैक मनी कब हो रही है, तो उन्होंने देखा कि ऐसा कोई भी प्रोपोर्शनल आउटकम अब तक नहीं आ पाया है जब से ये स्कीम इंप्लीमेंटेड है. फ्रॉम द 5-6 ईयर्स अभी तक हमारे पास कोई कॉन्क्रीट डेटा नहीं है कि ब्लैक मनी एक्चुअली कब हुई है. एंड इट इज वायलेटिव ऑफ द फ्री एंड फेयर इलेक्शंस. Free and fair elections means the corporate donors, how we ensure that they are not being biased towards a particular political party, and political party in the form of quid pro quo is not benefiting these corporations. So it is violative of free and fair elections itself. So therefore electoral bond scheme has been declared unconstitutional. National Cooperative Organics Limited. Ministry of Cooperatives, students, you understand, Ministry of Cooperatives has been formed and things related to it are important. Okay, now it is formed with the help of Multi-State Cooperative Societies Act 2002. Its headquarters is at Anand, Gujarat. Point is Organic India. We want to promote Organic India and the farmers who are participating here. The 50% of the profits made from the sale of organic products through NCOL will be transferred directly to the member farmers. एक स्कीम है PGS, पार्टिसिपेटरी गारंटी स्कीम. पार्टिसिपेटरी गारंटी स्कीम, अकॉर्डिंग टू दिस हम क्या करते हैं, वी आर गिविंग ब्रांड्स टू द फार्मर्स फॉर ऑर्गेनिक्स. दिस विल हेल्प देम अर्न मोर एंड मोर मनी. National Dairy Development Board, basically it is a promoter of the NCOL, National Cooperative Organics Limited. It's a multi-purpose initiative that will help in mobilizing the organic sales in India, organic product sales in India. National Health Claim Exchange. देखो what happens, students, Pradhan Mantri Jan Arogya Yojana. You remember this scheme, Pradhan Mantri Jan Arogya Yojana? Now this scheme is paving a very vital role for insurance coverage based on the socio-economic caste census. Certain states like Jammu and Kashmir are there where 100% coverage is provided. यहाँ पर हमने एक बॉडी बनाई है, National Health Authority, NHA, okay, which has superseded National Health Agency, National Health Authority, and one body is that IRDAI, Insurance Regulatory and Development Authority of India. Both of them together are implementing National Health Claim Exchange. Problem is sometimes with the settlement of the claims, that how much money is due and how much money they will get. National Health Authority was, established by this scheme itself, Pradhan Mantri Jan Arogya Yojana, as an autonomous entity, and it has been implementing Jan Arogya Yojana since then. Digital Jan Arogya Yojana also, Digital Ayushman also. Health settlements, basically, we want to create an ecosystem where no issue is there with respect to whenever the card is presented, the ESIC card or the card related to the health coverage through the Aadhaar linkage that is provided there, so that hospitals, clinics, impaneled hospitals, payments are released very soon. Thank you guys. Let's meet tomorrow and cover more about current affairs.